in the course of verification, the numbers must add up. We do not understand the genesis of the foregoing assertion by the applicant, nor where in its judgment, in the majority judgment, did this court criticize the first and the second respondents' reliance on the minor KI case. On the contrary, what this court took issue with was the decision by the second respondent to declare the results that had not been tested against the transmitted results in Forms 34A from the 40,883 polling stations countrywide. This court disagreed with the first and second respondent submissions to the effect that the minor KI decision had relieved them of the duty to verify the results against Forms 34A. This was clearly stated by the Court of Appeal at paragraph 293 as follows. Quote, it was further urged in court by a number of counsel for the first and second respondents that by disregarding Forms 34A and exclusively relying on Forms 34B, the said respondents were simply complying with the Court of Appeal's decision in minor KI. We have already held that we find little or nothing in this decision to suggest that by deciding the way it did, the appellate court restrained or barred the first respondent from verifying the results before declaring them, or that it was relieving the former from the statutory duty of electronically transmitting the results. What the second respondent was barred from doing by the Court of Appeal and the High Court was to vary, alter, or change the results relayed to the National Tallying Center from the polling stations and constituency tallying centers under the guise of verification. End of quote. So, where does the need to clarify such a pronouncement by this court emanate from? We reiterate that the responsibility to verify results is not a creation of this court, but an imperative of the Constitution and Section 39, 1C, B of the Elections Act. The verification required of the first and second respondents is meant to ensure accuracy or prevent fraud, and also to confirm that the candidate to be declared president-elect has met the threshold set under Article 138(4) of the Constitution. It is therefore the duty of the second respondent to bring to the attention of the public any inaccuracies discovered by the verification of Forms 34A and Forms 34B, even as it declares the results as generated from Forms 34B to generate Form 34C. The effect of such inaccuracies on an election depends on their gravity or otherwise, and the second respondent must state whether the discrepancies affect the overall results or not. The institution vested with the mandate to make a determination of the effect of the inaccuracies is an election court, a matter clearly settled by both the Court of Appeal in the minor KI case decision and in this court's majority judgment.